Say and feel it. Please rise. Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division draw near. If you attend, you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have some 6 hours of argument time that has been requested, so I ask that you please keep that in mind as you request the time today. And as I call the calendar, remember that we have your briefs, we have the record, we're fully familiar with the facts of the case. Okay, People versus Najre Filyah. Six and 2 and 5. Needless Love versus Nisha.
Respondent Nisha, court has no questions. I will submit.
Questions? Thank you. Submission. Virginie F. versus Antoine L. and Antoine L. versus Virginie F. Submitted on both cases. I beg your pardon? Oh, I'm sorry. I didn't see you. Okay. Do you wish to submit? You don't believe the appellant is here? You want to argue against yourself? You want to? Okay. 2 minutes. Submission and 2 minutes. Vega versus MTA? 5 minutes, did you say?
Yes, 5 minutes. I think the respondent requested 3 minutes.
You didn't ask for rebuttal. Was that 4 minutes and 1 for rebuttal? Okay. 4 minutes and 1 for rebuttal, and you asked for 3 minutes, sir?
Yes, Your Honor.
Thank you. People versus Kashif Matthews? Submitted. Kitziger versus 219 Avenue A? Submitted. Chelsea Properties versus Westco Insurance?
Count 6 and 2, Your Honor.
6, 2, and 5. I'll do 6, 2, 4, and 4. TRB Acquisitions versus Yadid?
Count 8 and 2, Your Honor.
Give you 6, 2, and 3. Goncalves versus the City of New York.
Respondent 6, please, Your Honor.
6, 2, and 6. Barrero versus Commissioner of Social Services. Submitted. People versus Sam Valentin.
Appellant
5, 1, and 5. HOV Services versus ASG Technologies. I'll give you 6, 2, and 6. Remember, if we have questions, we will ask them, and you will be able to continue in that instance. People versus Randy Gonzalez. Submitted. City of New York versus Philadelphia Indemnity.
Appellate 5 to 2, please, Your Honor.
There. Yeah. 5, 2, and 5. People versus John Nosea. Did you say 5? 5, 2, and 5. Elite Wine versus Michelangelo Preservation.
Appellant requests 5 to 1, Your Honor.
5, 1, and 5. Joseph versus Eden. Submitted. Suresh versus Krishnamani. Submitted. I beg your pardon? First case for argument, People versus Nair Filyar.
Good afternoon, Your Honors. May it please the Court. Natalie Ray of the Appellate Society for Mr. Filio. The question in this case is whether the Court's instruction, "do not speculate," was a meaningful response to the jury note asking specifically whether the intent to protect oneself was the intent to benefit oneself.
Well, counsel, was there testimony about protection? Or I think what the question really that the jury asked was if someone was under threat. Was that the testimony that was given by the defendant?
Yes, Your Honor. I mean, not quote unquote,
Right.
but he was scared from the time he was in the building at night without permission. He was scared that he was.
Well, I don't recall him saying he was scared. He certainly did not say, we can all agree that he did not say under threat, but he said he picked up the bottle, I believe. He picked up the bottle because he wasn't sure, since he was in the building, if anybody would have been there to get him. So
To protect himself.
to protect himself. But that doesn't mean that he was under threat.
Well, I mean, he felt, the question was, the question was not what the court says, I think is a misunderstanding, which is that he was never personally confronted. Yes, he did not have a personal confrontation, but he testified that he took these items to protect himself. And therefore, it was not speculation. The fact that he may not have said technically under threat would be a really narrow reading of the note by the court when the Court of Appeals has made it clear that when a jury writes a note, they're not lawyers, they're not judges.
The judge, so there are two things. First, there's a difference. If somebody is under threat, then there are certain things that they will certain statements that they'll make, perhaps so that the jury can understand that they're under threat. So that wasn't said. What he said was he took the bottle, as you said, for his protection, but he didn't say protection from what. There was no actual statement made by him to suggest that. So at that point, wasn't the judge accurate in saying that it was speculation? And my second question, my second point, I'm going to let you answer, is wasn't there plenty of opportunity for the jurors to come back with questions?
Okay, so that the first question, he was never actually, face-to-face with an attacker, yes. But you can be under threat when you hear he heard noises on the 9th floor. That's enough to feel threatened. He said he was threatened. He even said he was convinced. There was a sound on the computer in the salon at one point. He was convinced that the noises and the voices he heard on the 9th floor were people who had set off the beep on the computer. He clearly felt threatened by the noises he was hearing,
So,
not a
Counsel, I'm sorry, just to interrupt you. I don't believe that was his testimony. He clearly stated, yes, that he did hear individuals outside, but he did not, he said he heard people walking around, so he rushed outside. But he never said that he felt threatened by these individuals on the 9th floor or thought that the individuals on the 9th floor presented any threat to him.
I agree that he did not, quote unquote, say
It's not even a quote unquote. He didn't say it, period. I mean, I just think you're mischaracterizing his testimony. And I also want to get back to the point that the issue is, and the issue with the jury, which was kind of clear, was they were asking this question in terms of the definition of personal benefit, right? So the question from the jury was, if you are under threat and you take something for personal protection, is that considered to be for personal benefit?
Correct.
And that's where the judge gave the instruction, in addition to rereading the charge as to criminal possession of stolen property. That's where the judge also gave the charge in terms of speculation. So we're talking about personal benefit.
That is right. We're talking about personal benefit. The question went straight to the defense to the criminal possession charge.
Right, that he did not take it for his personal benefit, but rather he took it because of some type of...
To protect himself.
To protect himself. And his testimony, by the way, again, was he grabbed the liquor bottle for protection in case anyone sought to harm him for trespassing. There was nothing about an immediate threat that he felt.
But that would be a completely different situation if he had talked about an immediate threat. That wasn't the question, but we have a testimony.
But when he was arrested, he immediately admitted, and I think all through the testimony in the trial, he admitted that he was trespassing. He admitted that from the beginning.
That wasn't the question for the jury. The jury's concern was not whether there was trespass or not trespass. What the jury was concerned about was, his defense was, I took it for personal protection. That's what they asked.
I took it for protection in case anyone sought to harm me for trespassing.
Correct. And he heard people in the building. Therefore, the implication was...
No, but I see that's where I disagree with you. Or that's where I have a question with you in terms of the implication. I mean, I think that he could have simply testified if, in fact, that threat that he felt in terms of the trespassing emanated from the folks on the 9th floor, I think he would have testified to that.
He said that scared him. I'm sorry, I forgot your second question, Your Honor.
No, the second question was just whether or not they had an opportunity to ask questions. If there was any need for clarification, she said that they should come back, and she read the charge specifically pursuant to the penal law.
Your Honor, the court...
You can answer that and elaborate further on rebuttal.
Sure. Thank you.
May it please the court, Emily Galt on behalf of the people. The court's response to the jury note instructing the jury not to speculate, followed by rereading the main charge, was entirely meaningful.
So to that point, meaningful, it was quite clear, I think, to everyone, the judge and the lawyers, that when the jury came back with the question about if someone is under threat, I think it was pretty clear at that point that they were talking about his statement about, because I think they said, and they take something to protect themselves, that they were talking about that. Was the judge's response really meaningful under those circumstances? Or was it the judge's responsibility to say, you know, that is not something else. That is not exactly what is in the record. We can read back the testimony if you would like. Let us know, you know, by way of a note or something else. I mean, it was clear. But given what the judge said, was she instead undercutting the defense in this instance?
No, Your Honor, she wasn't undercutting the defense whatsoever because, as Your Honors has pointed out, defendant was never under threat. He did not use the property for his self-protection. So the judge saying not to speculate focused the jury back on the evidence that was actually presented. Defendant wandered around the salon for 30 minutes. He was going in and out of the suites, through the cabinets, in the refrigerator. If he really...
But that has nothing to do, that, you know, it's clear to everyone he trespassed. No one was under any misapprehension about that. The question was, they specifically had a question about the law. If somebody is under threat, if they trespass and they're under threat, does that change, you know, whether it's for their benefit? That was really the issue. So that was his defense, and I'm asking you whether or not there should have been a statement by the judge to speak to that issue or help the jury. That's what it means. You're supposed to help the jury in understanding the real question rather than just, you know, dismissing them. The jurors don't have the transcript. They don't have it to read, so they're going by their memory, and this is somewhat, that's what they remembered.
Well, first, the jury's question just simply wasn't based on the facts and evidence. It was based on this hypothetical situation. And if the jury was confused about the judge's response or had further questions, they could have sent another note. The judge's response, she said, I'd be happy to answer more questions. And in fact, the jury did send 3 other notes related to the burglary charge. So the jury clearly knew how to ask questions if they were confused.
Well, is there an argument that what the jury really meant to ask was when the defendant testified that he took the bottle because he felt, and you know, forgive me, I can't remember the exact quote, my colleague stated it earlier, was that to his benefit? You know, was that under those circumstances, was he taking it to his benefit?
Well,
that would have been an okay question, right? That the judge would have had to have answered?
No. The jury didn't ask that, though. The jury asked...
I know what the jury asked, but I'm saying that was what they meant, and everybody knew it, including the judge and the attorneys. But the jury doesn't have a transcript. And so was it the judge's responsibility to assist them in what they were seeking?
If the judge further elaborated and actually were to have answered the question, it would have destroyed defendant's defense because, as defendant says in their brief, you know, the judge could have responded with the penal
because
law
the answer to the
definition.
question was, no, it really didn't help you. It still is not to your benefit. That's what you're saying, that the answer that the judge would have given would not have helped because it was not to his benefit.
Right, because benefit is broadly defined as any gain or advantage, and it doesn't have to be a financial gain. So taking something for personal protection...
What you're speaking to is harmless error.
I mean, it definitely was harmless error. I mean, defendant admitted when he was arrested that he took 2 sips from the bottle, so that alone was enough to show his intent to benefit himself. So yes, it was definitely harmless error. Defendant was not seriously prejudiced, but the judge's response was meaningful. And if Your
Any
Honors...
questions? No. Okay, thank you.
Thank you.
Of course, we disagree, and I think that reasonable minds can differ on the interpretation of under threat. But the response of the court saying, didn't leave any opening for clarification. It said, as to the second note, calls for speculation, and as such, cannot be answered. Not may not be answered, not come back and whatever. No, cannot be answered. And then
cannot be answered based upon the testimony, based upon the record. It cannot be answered. But she did go on to say that if the jury had any additional questions or needed any additional clarification, they could send out another note. And it was mentioned they sent out, I think, 3 additional notes.
As to the burglary, Your Honor, they were completely.
But they were not precluded. She did not say, okay, you can, if you have any other questions other than as to the criminal possession of stolen property, send a note. She said, if you have any other questions or you need any further clarification, send out a note. They only sent out a note as to the burglary.
I mean, I think you can parse out the question, the answer that way. You can parse it out another way. As to the second note, meaning your question, jurors, as to criminal possession and the intent, as to that
Counsel,
note.
where is it in her statements after reading the charge regarding speculation and the criminal possession of stolen property, where in that does she state to them that's the end of any inquiry as to criminal possession of stolen property or as to the definition of benefit or personal benefit, and that inquiry is now closed? You can't send out any other notes concerning that issue.
Well, I don't think that a court would do that, Your Honor.
Right, but you just seem to you seem to state or that perhaps that's what she did, and I don't see that that's what she did.
I'm saying that it is easy for the jury to interpret.
And
I
so
will say
what
that-
would have led the jury, my question is, what in her statement would have led the jury to such an interpretation?
Well, let me go back to the fact that this is not an answer, it wasn't an answer, meaningful answer. At the very least, the court could have said, it's a question for the jury. This is not
Not a question, but it's not a question for the jury, so that would have been a misstatement of the law.
what the intent of my client was.
No, what it means to benefit. That's not a question for the jury.
The benefit, in this case, they want to know factually whether the intent to benefit, to protect oneself is equal to. And I will, if I may, Your Honor, the court didn't say once to not speculate. It said it 3 times. In addition, you are reminded of my instruction not to speculate. Again, you must not speculate about what you might have happened or could have done. You may not play the role of detectives. I mean,
Thank you.
This is a very serious, this is a directed verdict, Your Honor, and we ask for reversal. Thank you.
Thank you. Thank you both. Virginie F. versus Antoine L. Okay, so now there.
Good afternoon, Your Honors.
Good afternoon.
Joseph D. Simone for Cohen Clare Lands at Elia. May it please the court, I'll be very brief. This is a garden variety a legal fee award in a matrimonial type case, a custody matter. They're issued all the time to level the playing field between 2 litigants in a very contested custody case where there's a wide disparity in the financial situations of the parties. There is no doubt that the court established that there was that wide disparity. My client made $37,000. The appellant made $1 million. The appellant had $4.6 million disclosed in his bank accounts and liquid assets and $9.3 million in non-liquid assets. On his disclosure to the court, my client had $140,000. So it was within the sound discretion of the court to make the award in this case, which is ongoing. We continue our custody trial tomorrow, indeed. The appeal, I will note, this is my final comment, the appeal of the money judgment has been rendered moot. The money has finally been paid. I would respectfully submit that the entire appeal is moot because the award has been paid. I have nothing further, Your Honor.
Thank you. Vega versus MTA.
May it please the court, Justin Gardner for the appellants, Metropolitan Transportation Authority and MTA Metro North Railroad. The question before the court is whether my clients were entitled to summary judgment dismissing the Labor Law 240 claim where the undisputed facts showed that the plaintiff, Carlos Vega, was injured while attempting to move a rail that was in the way of the work site. They had rigged it up such that wire was connected to the rail.
Yes, and the wire broke. We
Yes.
understand what the facts are. So liability isn't just limited to being struck by falling objects. It can also be where the harm flows directly from the application of the force of gravity to the object. And here, they are pulling, lifting this object, and there's not much clarity in the record as to exactly how this is happening, but that they've rigged this thing so that they could grab it and lift this and pull it over some rails.
I would disagree with the characterization as lifting. They were pulling it horizontally, and it was resting on pipes such that it was rolling or dragging along the ground. And you know,
I didn't see anything with that level of clarity dealing with the words horizontally or anything like that coming from Mr. Vega as I read the transcript.
Counsel, is there anything that can fairly be said to be an elevation differential per runner?
there was no elevation differential. He fell backwards onto the same level that he was standing. When the wire broke, the momentum from the force of him pulling along the ground caused him to fall backwards on the same level. If this was a labor law 240 case, then I'm not sure what type of construction accident would not be a labor law 240
Also,
case.
this is a summary judgment motion, right? So we
Yes.
have, depositions have happened, we're reading his transcript, and I didn't see any place, and I'll ask your opponent, where there was an elevation differential.
Well, with regard to Runner, he is going downstairs, but it's the fact that it's gravity that is to the object that causes the force of gravity to the object. Here, he's lifting up this object. That's arguably what's happening. And it's the force of this thing, the force that he is applying to it that causes him to fall backwards. So when it disconnects. So wouldn't that be
The force
in the
would,
same way that he's propelled down the stairs in Runner, this gentleman is prepared backward when the object he's holding goes in the other direction and he leaves it.
I think that the critical distinction is that there were stairs involved, so there's an elevation differential.
So
that
the
would
critical
cause-
distinction isn't what they say in Runner as to the application of the force of gravity to the object?
I don't see where there was any application of the force of gravity to this particular object because it was resting on pipes on the ground. It was being pulled horizontally, and
Well, I
it
guess
was the
that's-
force of
that's-
momentum.
So counsel, this is Judge Gonzalez. I'm going to ask you some questions from it. I'm on the screen.
I see that, my apologies.
Hello, it's okay. I'm going to ask you this from a different angle, no pun intended. So with respect to the testimony of Nicholas Pistro from Tishman, he acknowledged that Tishman was responsible for moving objects, including rails, not the laborers who were performing this concrete work. And similarly, the supervisor or superintendent, rather, from Tishman, Sean Fury, testified that the rail was too heavy to be pulled safely. So, given the testimony of these two persons who are in the employ of the defendant, Tishman, how do you get away from the fact that it appears that some type of device needed to be used to pull, lift, move a rail that was several hundred pounds, and how many feet in diameter, in length? It was 15 by 18 feet long, right?
Correct.
So what do you say to that? This is a testimony from your own people.
We don't contest that. That goes to the means of how to move it. And it could have been cut into smaller pieces and lifted and moved that way. It could have used a device to lift it, but they weren't hoisting or lifting it when the accident occurred. It was the force of the momentum of pulling on a wire that broke that caused them to fall backwards on the same level. And it's our position that takes it out of the purview of Labor Law 240. And even
So you have a motion to dismiss before us, right? This is a motion to dismiss, not a motion for summary judgment.
Incorrect.
Where there's been,
That's incorrect. It
wrong?
was a motion for summary judgment. It was.
Am I wrong?
Anyway, thank you very much. You have some
Thank
rebuttal.
you.
Thank you.
Counsel?
May it please the court, Vincent Chirico for the respondent. Three quick points.
Counsel, one quick question. Is
Sure.
this a motion for summary judgment or a motion to dismiss?
It is, Your Honor. There's a confusion because the
No,
motion.
which one?
Summary
Which
judgment.
one?
It is a
It's a
summary
motion for
judgment.
summary judgment.
It is. It is. Summary judgment seeking to dismiss the 240 case.
Thank you.
So to Justice Moulton's question as to whether there's an elevation differential in the case, the word lift is all over this record. Plaintiff testifies that he and the co-worker...
Give us chapter and verse, counsel.
I'm sorry?
What record numbers?
Sure. Page 274 to 277 is plaintiff's testimony where he testifies that he and co-workers used shovels and an excavation bar to lift the rail up so they could place electrical pipe under it so that the rail can then roll along the tops of the pipes.
Okay, so, but the accident happened when it was on top of the pipes, correct?
Well, that's not necessarily true, Your Honor, because you have the Tishman witness who says that they were trying to lift the rail while plaintiff was pushing down at the bar when the accident happened. He then contradicts that testimony.
Record sites?
That is page 574 in the record.
Well, for your client's testimony, page 276 of the record, he says, we took a shovel to lift it little by little. Then he says, I think they used a crow. So you use your shovels kind of as a lever to lift it up off the ground. And he goes, no, with shovels.
That's right, Your Honor. And then what they did was they tried to put the pipes underneath, and they used the excavation bar with plaintiff pushing down on it in order to lift the bar. And while he's pushing and the other side is pulling, the wire rips, breaks, and causes the...
So he says that the accident occurred when he's lifting, excuse me, he says that the accident occurred when he's lifting and his coworkers are pulling.
That's correct.
So is that enough for elevation on the runner?
Yes, Your Honor. And to supplement that, you have Mr. Presto, who's actually the MTA witness, the appellant's witness, who says he sees on page 477, he sees workers trying to pick up the rail. So you have three different witnesses that
Counsel,
say...
I'm sorry to interrupt you, but I'm looking at record 288, and maybe this is all over the map, but there he says he's pulling when the wire snaps and he falls backwards. So I thought he was pulling on the rail, and there were other people pushing from behind. Am I mistaken?
Yeah, Your Honor, it's the other way around. He's pushing down while the other side is pulling. There may have been some inconsistency in the record between pulling and pushing. But the issue here is that under this court's holding in Green, you don't even need lift. You need the absence of an adequate safety device, and that wasn't...
Counsel, I just don't buy that. I'm sorry. I mean, even Runner, which is a very liberal case, says there must be an elevation differential. It posits the possibility of having a de minimis elevation differential, which is something maybe this happened here. But here it seems the forces here are not... I mean, gravity's omnipresent, of course. It doesn't go away. But here it seems like the forces were inertia of a heavy object not wishing to be moved and wish to stay in place, and friction, which, in other words, the friction was making it very hard to pull this thing along the ground. And I agree with you that it was absolutely an inappropriate way to move the thing. But is it a 240 violation? I'm just not seeing it.
Well, Your Honor, under settled First Department precedent, if the item that they're trying to lift without an adequate safety device is lifted even minimally, and the base sits on the same level as the plaintiff, at the very least, there are triable issues of fact here. And that's our position on this appeal. And if there's no other questions, I thank the court for its attention.
I did want to clarify one thing that I believe was a mistaken statement in respondent's argument. Plaintiff Carlos Vega was at the front holding the pipe, pulling on it. He was not the one at the back. It was a different gentleman by the name of, also named Carlos Campoverde, who was pushing it from the back. And I would cite the record at 287 to 289 and 774 to 775. There were two Carloses on the job. The plaintiff was at the front pulling backwards with the other gentleman from Commodore named Simon
He was pulling
Bailey.
backwards, you mean to lift it?
He was holding a pipe connected to the rail by a wire, pulling backwards, hoping that it would roll along the pipes that they had placed under it. And it didn't move. The wire broke instead, and he fell backwards.
Right, I mean, that's really consistent with his statement. But to your adversary's last point, I believe he was referring to Gutierrez versus Harco Consultants, where we said that if a hoist had been made available, well, in this case, if a hoist or the proper means and method or the proper equipment had been made available for them to actually lift these rails or whatever, would the accident would not have occurred, and therefore it would have been sufficient in terms of a pulling device, right?
If you're saying that a hoist could have prevented the accident, I'm not going to contest that. Other options that could have prevented the accident.
My point is that under our case law, and I'm looking at Gutierrez, had the proper equipment been made available, then you would not have had this issue in terms of pulling or lifting. And the fact that plaintiff testifies that the proper equipment was not made available, and coupled with the references in the record to actually lifting, is that not sufficient?
Labor Law 240 doesn't apply to every situation in which equipment that would be proper to perform the job was not provided. For example, they could have welded it and cut it in pieces and carried it away in pieces, but that doesn't make it a Labor Law 240 case. There has to be an elevation differential.
But they couldn't cut it in pieces because Tishman and whoever was controlling, the same people who should have brought in the device, didn't have the ability to cut it. So that is all over the record. So we're really focused on the question my colleague asked about the device.
They have a Labor Law 200 and a negligence action against Tishman, in our opinion, for that. So, but that doesn't change the fact that there was no elevation differential to make 240 apply in this instance.
Did you ask the question about the device?
A device would have been one option to have prevented the accident. I agree with that. But I don't believe that Labor Law 240 applies in every instance in which a hoist or device is not provided when there's no elevation differential in the first place to cause the statute to apply.
Thank you. Thank you both. People versus, Chelsea Properties versus Westco Insurance.
May it please the court, my name is Josh Hummel and I represent the appellants. The issue here is whether the motion court improperly ruled that people who were barred from access to a building as a result of cascading bricks, that those buildings did not qualify in that situation as entities that could be occupied for their intended purpose. Motion court ruled that notwithstanding the fact that tenants were directed that they could not enter or exit until various repairs were made, and commercial tenants were told that they had to shut down their businesses and had to come back the next day to make sure that
Counsel, does it matter that the DOB violation did not contain any prohibition?
So you're referring to the emergency DOB violation. That you're correct.
Dated August 7th, yeah.
Yes, you're correct that it did not state that people had to vacate, but all of the testimony, and this is a motion for summary judgment, all of the testimony unrefuted was that instructions were given. You have affidavits from commercial tenants saying that this is what they were instructed, and nobody came in and nobody went out until the repairs were made. The fact that the repairs only took 4 hours was, was to some degree fortuitous. The policy doesn't define a temporal requirement, although it could have, in connection with what does it mean for a building.
Would there be any period of time that would be de minimis, like half an hour? Just take a hypothetical. Would that still be, would you prevail
Right,
if they were only excluded for a half hour?
That's obviously a road that, in terms of testing it, that we can go down. And one would suspect that, or I think the argument would be, if it was merely a half an hour, one would have to question what exactly fell that would constitute this collapse. But the fact of the matter is, these are policies of adhesion. The carrier has the power of the pen. There are plenty of definitions in the policy, and they could have very easily identified, if they sought to do so, a temporal requirement. There are no cases that have dealt with this specific situation in this type of a case on these particular coverages. This is a very strange fact pattern in that regard. But nonetheless, that would not empower a court as a matter of law to determine, to use the motion court's words, that this was mere inconvenience. One person's mere inconvenience would be another's prohibition. People couldn't go in, people couldn't come out. The commercial tenant couldn't continue to operate. It would certainly seem to me that that would be at the very least an issue of fact as to whether the building could still be occupied for its intended purpose. There's also, I want to be clear, because there's a lot of stuff that's written. There is nothing in the case law when things fall, when there is this abrupt, when there is an abrupt occurrence, that there needs to be structural integrity, a violation, a danger of structural integrity in order to constitute a collapse. Those cases had their...
I don't think that's a problem you have to deal with that much. I mean, you get brained by a decorative element, it's the same to you as if you get hit by a structural element.
Okay. In addition...
let's talk about 154 versus 156 for a moment, because there's that photographic evidence that appears to show that 154's bricks did not fall of their own, rather the fire department.
Sure, so what I would say to you is I would focus on two photographs. I know the record's relatively extensive, but I'll just give you two citations. The record at 2393 and 2916 are the photographs that I would ask you to look at. And you can see, I would submit, you can see that the bricks are, some bricks have fallen. You also have their expert saying that there was a frontal failure at 154. And what I believe happened was some of the bricks began to fall at 154 and more would have over a short period of time, but for a lot of the bricks at 156. The bottom line is that I don't think, again, on a motion for summary judgment, one could tell whether or not or to what degree the bricks at 154 were falling. The photographic evidence is not clear, and we do see some damage. It's not like you don't see any damage at 154. The amount of the bricks, or speculation as to whether some of the bricks were pulled down by the fire department or by the police department or by adjusters, that's...
Counsel, the DOB summons that was issued to 154, found it in the record at 1034, references the, let's see, the facade collapse at 156, which affected the facade at 154. How does that play into what you're saying?
So I think it's consistent with what I'm saying. So there's no question that most of the bricks that we see came from 156, and those bricks began to pull down at 154. So if I'm at the DOB and I'm writing, I'm seeing all of this from 156. I'm seeing how it's affecting 154, and I'm writing a report that says that the bricks at 156 began to affect the bricks at 154. You've got buildings; these are right next to each other. So you start having a pull there, and then you have a pull in the next property. It's still bricks coming from 154. irrespective of whether those bricks fell on their own or those bricks fell because bricks from
I'm
156
looking
came
at the
down.
difference in the language of the two violations. The one issued to 156, found in the record at 1036, references facade failure at 156, but it doesn't say anything like that about 154.
Because because a lot of the bricks at 154 had yet to fall, the facade failure, and therefore, as you see it, there's the beginning of the facade failure. In 156, it is, it is right out there, right in front. At the end of the day, that's still a question for a jury to decide in terms of the extent of damage, and now you're just talking about the amount of damages. But it's not like there were no bricks from 154, and the question is, to what degree was 154 damaged based on the bricks that did fall and the bricks that may have also were going to fall? But certainly...
Thank you.
May it please the court, Kevin Buckley on behalf of Wesco Insurance Company. There are at least 4 problems with plaintiff's interpretation of the operative contract language here. First, the additional coverage for collapse does not apply unless part of a building that could be occupied abruptly falls down such that it cannot be occupied, like a north wing, like the 4th floor. The term part of a building is used twice in the same sentence.
Counsel, isn't it clear that the commercial spaces couldn't be used for the rest of the day?
They could be used for the rest of the day, and my point here...
They could?
So, could or could not?
They could be used. They were asked to close their business so that the shed could be erected in front.
Right, the shed was erected as of 10 p.m. Roughly. The shed was finally done at about 10.
Yes, it was done at about 10 p.m.
Okay, so one of them was a dry cleaner, right? Dry cleaners don't stay open that late usually.
Correct, Your Honor. Correct. Just like if there was a car accident in front of this facility and the emergency responders asked the businesses to close so that they could do their investigation. The point of this provision is that the collapse prevents the occupancy of the space, not a restriction of access to the space. It's completely different what we're talking about here. If you look at the language...
I'm sorry, I did not understand that. Could you explain that again?
Sure.
I do not understand. How would they be able to carry on the business?
It's not that they're able to carry on business or if access is restricted, such as if the city closes down the street for a parade or an emergency or anything else.
Counsel, you're not making sense. One brick can kill a person.
Yes.
So if the first, we're agreed, right? We don't need any proof of that, extrinsic proof of that. So if the first responders tell the people in the commercial space and tell the people in the residential units out, you're saying that that's something that those people can ignore and they can just stay in the building?
No, they can't ignore. But that is not a collapse of a part of a building that prevents it from being occupied permanently.
Your issue is with the fact that it was the facade that failed?
No, my issue is multifaceted. My issue is with the fact that this was a temporary restraining on the access to the premises so that a shed could be erected. The purpose of the shed was not because of the collapse. The only purpose of the shed was to prevent other bricks from falling down and injuring people, which is legitimate.
Isn't that the same thing?
No, it is not. Because if this room collapses, we cannot occupy it. If something collapses on the way outside of this building and I cannot access it for a couple of minutes or hours, that just merely blocks my access, restricts my access. It doesn't prevent, as a result of the collapse, the occupancy of this building as it intended to be occupied.
Of course it does, because again, what we're talking about is falling bricks. You have to ensure that there are no additional bricks that will be falling, which could injure the occupants of the building.
Yeah, that is legitimate, what the government did here to prevent the safety of individuals, but what this provision only covers is an abrupt falling down of a part of a building so that that part can't be occupied again, like the collapse of a building. And that's why the Eighth Circuit
So
said,
it would not cover the falling of bricks? What would it cover?
no, it would cover if the north wing fell down, or if the entire
So
building
the
fell down.
entire building would have to fall down?
The entire building or a part of a building, such as the wing, the fourth floor.
I see.
That is what the Eighth Circuit said in Tower,
So we're not in
Council
the Eighth
Tower.
Circuit, Council, so we're not in the Eighth Circuit.
I understand.
Right. So, so where in the policy or any place does it specify the language that you're talking about?
Yes.
Part of the building excludes building facade.
Well, it says in the operative language, abrupt collapse means an abrupt falling down or caving in of a building or part of a building, with the result that the building or part of the building cannot be occupied for its intended purpose. So it's saying what falls down must be what cannot be occupied. And that's not what happened here.
Does it really
Thank you.
say that?
I believe it does, Your Honor, and that's how the Eighth Circuit interpreted this as well. What this would do is, if it's expanded, is if anything falls off a building, such that we have local law 11 here, if people are encouraged not to maintain the facades and something falls off the building, DOB can come and now the insurance company has to pay for maintaining the building, rather than what should occur here is the insured should have to maintain its facade and correct the condition here.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Brian Barnes for Union Mutual Fire Insurance Company. Judge Gonzalez made a point that I want to circle back to concerning 154. My client insured 154. There was a question about the difference between the violations that were issued, and that prompted a response from Mr. Mallon about how bricks had yet to fall from 154. But if we look at the language of the provision and we look at the case law in New York, that is a key point. A building or a part of a building that's in danger of falling down or that is in danger of collapsing or caving in is not considered to be in a state of collapse when you're dealing with this policy provision. It has to be an abrupt falling down or caving in of the building or part of the building. Now, what I would submit to the court is that the record overwhelmingly shows that there was not an abrupt falling down or caving in of 154 at the time of the loss. How do we know that? We have photos. And we know these photos are taken shortly after the loss, right? If you look at the record, we understand this incident takes place sometime around 6 p.m. at night. And we know that the scaffold and the sidewalk shed gets put up at about 10. The photos that you see that depict the bricks fallen from 156, but not fallen from 154, there's no sidewalk shed up and there's daylight enough that you can see the building, right? So we know from that those photos must be taken shortly after the time of the loss. And those don't show bricks off of 154. I would direct the court to a few sites in the record, photos at 1025 and 1026.
But DOB's summons stated that because, that the 156's facade collapse affected the masonry facade at 154.
I wouldn't dispute that the facade might have been affected, Your Honor. What I would dispute is that it abruptly fell down or caved in, which is what the collapse additional coverage gives coverage back for, right? We would submit there are exclusions that would apply here, right? The engineer who went out for the DOB, Mr. Silo, plus Union's expert, looked at this building and said, this building's 100 years old, there's age-related decay, deterioration, wear and tear present, right? Those exclusions would apply to this loss, but for the collapse additional coverage, right? In order for them to find coverage, I would agree that those exclusions do not apply to the additional coverage. I'm not making that argument. The argument I'm making is those exclusions apply to the loss as a whole with respect to 154 because there is no abrupt falling down or caving in of the facade at 154 at the time of the loss. Unless the court has any other questions, I will cede my time.
Thank you.
Thank you, Your Honors.
Just hearing counsel's argument, I still even though as he's talking about the photographs, and as the Department of Buildings wrote that violation, clearly they were seeing that there were some bricks that fell from 154, certainly not of the magnitude of 156, but as long as you meet the sudden and abrupt requirement of the policy, then that still you still have to analyze it from the perspective.
Counsel for Wesco made the point that the building needed to not be, or part of it needed to be unable to be occupied. Now, there were tenants in the building, both buildings, were there not, that were in the building, occupying the building? They were just told, don't leave the building.
Correct.
So is that a distinction? He was making the distinction between occupying it and
access versus
access.
occupancy. I mean, I would say that's a overly legalistic argument that has no support in the policy. You know, occupancy has very defined words. Occupancy means a lot of things, and we've seen case law that talks about residency versus occupancy. But certainly, if you can't move in or out, then you can't occupy it for its intended purpose. It's not occupy, quote unquote. It's occupied for its intended purpose. Occupied can be defined as moving in or out. I want to pick up on something else, because what Mr. Buckley did was he added a word to the policy that doesn't exist. When he suggested that the part of the building had to have a linkage to the occupancy, he inserted the word that. If you look at the particular language, it says part of a building, any part of a building with the result that the building, and it just says, or part of the building cannot be occupied for its intended purpose. What it doesn't say is the result that the building or that part of the building cannot be used for its intended occupancy. So what he has done is he's basically said, I'm going to add a restriction. If you only have part of the building, then you have to link the occupancy to that part of the building. Ipso facto, no.
Counsel, I thought it says any part of a building with the result that the building cannot be occupied for its intended purpose.
With that, the building cannot be occupied for its intended purpose. That's correct, and the building could not be occupied for its intended purpose. My point is that Mr. Buckley was suggesting that when you're dealing with a part of the building, that you have to focus on the part of the building could not be occupied for its, and that's not in the policy, and that goes to one of your questions, because under that scenario, falling facade would never qualify, because you don't live in you don't occupy a facade.
Thank you.
Thank you.
Thank you all. TRB Acquisitions versus Yadid.
Good afternoon, Your Honors. May it please the Court, Burton Lipshy, Strickland Levan for the plaintiff's appellants. The issue on this appeal can be simply stated. It is whether this defendant can hide behind the litigation privilege when his agreeing to testify falsely against the plaintiffs was the fulfilling of a threat and blackmail and extortion scheme, and we urge the court to say that he can't.
Was there a scheme to blackmail here?
Well, a scheme, I suppose there was blackmail here. I mean, the allegations of the complaint, and I remind the court that this is on a motion to dismiss, and therefore the detailed allegations of the complaint need to be assumed to be true. The allegations of the complaint, specifically pages 25 to 33 of the record, make clear that what the defendant did was to demand that his brother give him $8 million, and if he did not, then the defendant was going to go to the adverse party of the plaintiffs in a separate lawsuit and give them false testimony that would be devastating to the plaintiffs.
Did
And
there
when
have
he
to
was
be some,
rebuffed,
did
that's
there have,
exactly what he did.
did there have to be any benefit? Did he have to gain any did he have to gain any benefit by what he did, Jack Yadid? Was there any, in this scheme
No,
he had?
I don't think that that relates to whether the privilege applies. Now, the privilege is said to be absolute. But of course, so is the true and fair report privilege of Civil Rights Law, Section 74. And so is the report to government privilege that the Court of Appeals adopted in 1958 in Brandt against Winchell. But in both of those situations, the Court of Appeals has since said that despite the language of it being absolute, it isn't absolute. And there are exceptions to it when the defendant abuses the privilege by committing a separate wrong. And the best example here, the one that's closest to our own case, is Posner against Lewis, which involved the privilege for reports to government. Because there, the defendant, like here, threatened the plaintiff that he would report him, complain about him to a public agency, unless the plaintiff did various things. And when the plaintiff didn't, he reported him. And the Court of Appeals said...
Counsel, in Posner, didn't I think it was the father-in-law in that case, didn't he do much more than what was done here? And that relates back to my first question as to whether what happened here qualifies as a scheme.
Well, he did more, but the point is the same, Your Honor. And whether we call it a scheme or a plan or whatever word we use, the fact is that the threat was there, pay me or else, and then the or else happened.
So the threat, the blackmail is, in your mind, that's sufficient?
Yes, sir. That would be our contention.
Is it blackmail, counsel, is it blackmail plus the fact that he approached, allegedly, he approached the Reebok people?
That is correct.
So you need that second element as well?
Well, he did do that. And, and that's the allegation of the complaint is that he did.
It's a pleading motion. Yeah, got that. But do you need both things? Do you need the blackmail or the extortion scheme or extortion plan, plus the fact that he went to Reebok? If Reebok, you wouldn't dispute that if Reebok had approached him, had gotten information from another source, that he had disparaging information, we would not be breaching the privilege at that point.
I agree with Your Honor. And of course...
So that's the significance of the unsolicited telephone call, right?
That he went to them, he threatened to do it, and he did it. You know, the question here isn't malice. If he had gone to Reebok...
Isn't it, counsel, isn't it malice, though?
No, malice...
You have someone threatening his father, his own father and his own brother, and saying, give me $8 million or I will do this while litigation is pending. Doesn't the absolute privilege extend to wrongdoing of this kind too?
It would apply, the privilege applies even when there's malice. If what happened here was he went to Reebok because he hated his brother, we would have no claim. The question here isn't motive. The question is conduct. It's a question of what he did, not why he did it.
So, counsel, if we follow your reasoning and your arguments, aren't we kind of carving out a new section or an exception, I guess, to the privilege?
Your Honor, this court has already recognized in the Martinson against Blau case, this court recognized, the Court of Appeals had created an exception to this very privilege, where the testimony is part of a fraudulent scheme. How different is that from this? The point is, and maybe the language of the Court of Appeals in Posner is most apt here. The Court of Appeals said, and again, that's the case of the complaint to the government. The Court of Appeals said, the dispositive allegation that places this case outside the realm of Brandt and the other cases cited by the concurring opinion is an affirmative act. Defendant's conduct in attempting to blackmail Posner. That's what makes this case different. And it comes within the kinds of exceptions that this court and the Court of Appeals has made to other so-called absolute privileges. The point of this privilege is to encourage candor, so that lawyers and witnesses are protected when they speak and when they testify in court against claims of defamation. This privilege was not intended to be a shield for blackmailers. I thank the court.
Good afternoon, Justices. May it please the Court, James Riley, Ovid Novid LLP, for Respondent Jackie Deed.
So, counsel, following up on your adversary's last statement, is that not what we would be doing, would be allowing the privilege where you have a situation where there is, we've been using the term blackmail, and this unsolicited, and kind of a following up on the threat or the blackmail?
So, first of all, Your Honor, I just want to clarify. So, below, the plaintiff's only claim was for breach of contract based on supposed statements that Jackie Deed made to TRB and Reebok's attorneys during an ongoing litigation. Okay, so all of this whole thing about any scheme or any conduct that happened outside of that is really just noise in the complaint. It really has nothing to do with the claim.
The complaint is that he breached the confidentiality agreement, right?
Right, he breached the confidentiality agreement by making comments
Right.
to Reebok, not by coming to his brother himself, who was already part of the confidentiality agreement, and making statements to him.
Well,
So-
I thought it was he breached the confidentiality agreement in connection with the buyout interest, right?
Correct, but the
So wouldn't it be
actual...
everything attendant to that or with that?
Well, no, Your Honor. My point only is that the statements that he made that they contend breached that provision of the agreement were the statements that he made to Reebok's counsel. But even aside from that, so there's another point I wanted to address, which is that counsel said that the point of the absolute litigation privilege is to encourage candor. That's really not the point of the absolute litigation privilege. The policy purpose behind the absolute litigation privilege is essentially to get as much pertinent information into the judicial process as possible with the least amount of restrictions and the least amount of chilling effect. Okay, and that's regardless, and we see this from countless First Department cases, that's regardless of whether that pertinent information is true, because we know that the absolute litigation privilege protects even statements that are deliberately falsely made, as long as they're made in a litigation and they're made pertinent to the litigation. So the whole basis of the privilege is basically the idea that society's interest as a whole is in maintaining this unfettered flow of information.
So counsel, I'm thinking through a whole number of scenarios that could fall under this aegis. So for example, give me money, as the situation is here, give me money or I will do this, and then I do this, okay? Or give me property, or give me sexual privileges, or whatever, or I will do this. Is that really what the privilege means to protect? Because we're talking not about just threat, we're talking about an alleged threat plus conduct. It's not just a threat.
Correct, Your
So
Honor.
how does that fall under the protection of the litigation privilege?
Because again, what we're dealing with here in this case are the statements that Jackie Deed allegedly made to Reebok and its counsel. So I think we're talking about two different things.
But preceded according to the plaintiffs, preceded by an extortion threat.
Correct, but
coupled with an extortion threat.
Right, but that's really not relevant to whether the absolute litigation privilege applies, because the absolute litigation privilege, as I just said, is concerned with ensuring that there's unfettered flow of information in the court system.
Would it make a difference, I'm sorry, would it make a difference if there was, I asked this question before, any benefit to anyone here? I mean, obviously Reebok benefited from this information, but the bad actor, the person who we're saying is, you know, if we want to call it that, didn't receive any benefit from this. Does that make any difference here?
So again, I don't think that is relevant to the analysis of whether the absolute litigation privilege applies, because the absolute litigation privilege is not the mechanism that is used to disincentivize this, you know, supposedly criminal conduct. There are other, and again, that's why there are other deliberately false statements made in the course of litigation is perjury. That's a crime. But the absolute litigation privilege is not the mechanism through which that should be discouraged. That's discouraged through other mechanisms, such as criminal prosecution, other things like that. And to get back to your point, Justice Renwick, that whether there was a benefit or not, then it really has nothing to do, you know, with the absolute litigation privilege itself, it really has nothing to do with the application of that. And just as an aside, as we say in the papers, you know, if you look at the record, what was supposedly demanded here was actually less than was actually won in the underlying proceeding.
$8 million is insignificant, therefore?
No, I'm not saying, but I'm just saying the benefit that he actually received in real life is greater than what you're saying, to go back to your point.
Thank you.
Thank you.
Just very briefly, Your Honors, I think that the answer, Justice Renwick, to your question is that it isn't so much whether there was a benefit as whether there was a harm. And the point was that—
But there's harm in litigation, isn't there?
Well, but
there is harm in litigation.
It was harm in the litigation.
And if he didn't threaten here, if there was no threat, and I'm not saying that there should, I don't know that whether he would have gotten a benefit would have made it worse, and I'm not saying that, but I'm just saying here, Reebok got the benefit, no question. What he did was provide this information, even though it was motivated by something negative, was provide information that was that advanced this litigation in some way. It really wasn't.
It didn't, he didn't get a specific benefit from his bad act because he was rebuffed in his attempt to you know, blackmail for the money. But the point was that the plaintiffs were harmed by his conduct. And just one last point is—
during cross-examination or examination of the witness, would that have not come out? Or did it not come out in terms of what was going on?
There's no way to know, Your Honor. There's no way to know what would have come out. But the fact that—
So let's just say he didn't have you know, there was no bad motivation. Let's just say he said, you know what, I just feel like you guys, we were not in this, it's not right not to provide this information. And he breached the agreement and went to it.
That's exactly what the privilege is for.
And that's exactly—
If that's what he did, we have no claim. We have a claim only because this should be an exception to there should be an exception to the rule, just like, and of course there was already an exception, as I said before in Martinson, this court, citing the Court of Appeals, said there is an exception to this very privilege. It's not just a question of—
But that's the whole point. You have to look to the motivation, right? You're looking to other factors. Are you looking to see whether there's a benefit? You're looking to see the motivation in making the statements?
But it's not just a question of motive. It's because there are cases that say motive doesn't matter. It doesn't matter that you hate him. It doesn't matter that you're a bad person. But this is different. This is about the conduct of the blackmail and the extortion, which makes it different. Just as it did in Posner, it makes it different. And I thank the court.
Thank you both. Goncalves versus City of New York.
Good afternoon, Your Honors. May it please the Court, Matthew Sakis for the plaintiff appellant Liborio Goncalves. The crux of this case is that the workers that were trying to load this 18,000-pound pipe onto the lowboy did not have the equipment to provide proper protection, and that's why Mr. Gonsalves was injured. The equipment that provided proper protection.
Counsel, we haven't had much discovery in this case, right?
We have not, Your Honor.
There's a 50H that you're relying on, basically.
Correct. That's correct.
Okay, I mean, given the complexity of what happened and the fact that the plaintiff didn't see, he heard something, but he didn't see the pipe fall, shouldn't we have discovery first before there's this type of dispositive motion?
I believe, Your Honor, that discovery would be appropriate if the defendant had raised a question of fact, and they didn't. It's their obligation to come to the court with evidence sufficient to raise a question of fact. Mr. Goncalves' evidence was that they did not have proper protection, that the pipe...
Counsel, if I may. So under the circumstances here, where Mr. Gonsalves was 15 feet away from the pipe that was rolling towards the car, and he stepped in to try to avert that calamity, don't we have questions of fact?
I do not believe so, Your Honor. This court has addressed that situation in the past. There's a case, Lopez versus Boston Properties, that I cited, where it is foreseeable that a worker faced with, as Your Honor properly described it, a potential calamity, will put themselves in harm's way, which Mr. Gonsalves very freely admitted that he did do that. The Lopez case was even, frankly, more of a worker putting themselves in peril. This was a worker who was on a ledge who, if I remember the facts correctly, basically jumped off of the ledge to grab a bucket that was potentially on its way down to may have killed a coworker or something. There was a dispute about whether or not he fell or he jumped, but I believe the court said that in essence, even if he had jumped, it's foreseeable in that situation with a worker who's got a safety line on, would put themselves in peril to...
But do we know what safety device would have protected someone who was 15 feet away and jumped in to avert a disaster?
Well, we certainly know, Your Honor. Oh, I'm sorry. I apologize.
Here I am.
I was wondering why I didn't see you. I apologize. We certainly know, Your Honor, the safety device that would have gotten that 18,000-pound pipe onto the lowboy safely, and that is the excavators that were at the insert pit. We're at the staging area. The excavators with the slings were what they always used in this situation to get the pipes onto and off of equipment, the lowboy, et cetera. They didn't have that. They were working with the equipment that they had, which was a loader, front loader, that was equipped with forks. That was not the proper protection. At a minimum,
I thought that there was testimony that from the superintendent or someone that the equipment was on site, and that plaintiff was mistaken in his 50H where he stated that it wasn't on site.
So what Mr. Sal Leopardo said in his affidavit is he said, well, he made the choice to use the loader, which is he made the choice to use the equipment that was available to him, which was the loader. The excavators were at the insert pits many blocks away. I don't know how far exactly.
I think that, excuse me, that goes to my colleague's question in terms of the fact that this is a motion for summary judgment. There has not been any discovery. So we don't know exactly what was on site, what wasn't on site. We don't know what equipment could have possibly prevented the accident from occurring, right?
Well, Your Honor, that was asked at the 50H. It was asked directly, why was the loader being used? And Mr. Gonsalves testified the superintendents specified that the excavators were over at the insert pit. That's why they were using the loader instead of the excavators with the slings, which would have been proper protection. And at a minimum, we know that this 18,000-pound pipe that was being hoisted with this front loader with forks, which you can imagine extremely unwieldy. You're talking about a 40-foot pipe, 18,000 pounds, and forks that are 5 foot apart. You have to really balance this thing very precariously. At a minimum, we know that the thing wasn't secured to the loader, wasn't secured to the forks. It wasn't chained on there. It wasn't strapped down. That's how it got off, and that's how it started to roll when Mr. Gonsalves had to then make the split-second decision to jump in and to try to get this thing stopped before something, as you indicated, a potential calamity could occur.
Counsel, wasn't there testimony that what the plaintiff did in jumping in front of this moving object was against policy?
And again, it was another thing that Mr. Leopoldo said in his affidavit, which was self-serving, and he doesn't say what the policy was. He doesn't say what would be the appropriate thing to do in that. He just simply says, well, that's against our policy. And I don't think that his just saying that raises a question of fact. As this court's indicated in other decisions, and again, we talked about the Lopez case, you know, it's foreseeable that in that situation that a worker is going to potentially put themselves in harm's way to avert what could be a catastrophe. May not be, but in a split second, it's very hard to know that. So with that, thank you, Your Honors. Thank you for your time.
May it please the court, J.C. Chen for respondent, City of New York. So at the very minimum, in the best case scenario for the appellant, the motion for summary judgment is premature. It relies almost completely on a 50H hearing that occurred where the appellant admitted that he didn't see how the pipe fell, and by the time he saw the pipe, it was already rolling. Because of this fact, more discovery is needed, and at this point,
Counsel, can we say from the mere fact that the pipe was rolling, that gravity was working on the pipe, and it was propelling it?
Can you ask that
Did you
again?
hear what I
Sorry.
said? There's some question that you raised in your papers about whether this was a gravity-related event, or there was an income, or rather a altitude, or there was a differential of height.
Yeah,
So what I'm saying is, like, if the pipe is rolling, doesn't that mean necessarily that gravity is acting upon the pipe?
It does not, because right now, based on the records that we have, it's unclear what has caused the pipe to even roll in the first place. And in the past, this court has held that a rolling device like a pipe is not considered an event that's covered under 240, because 240 usually applies to when a worker falls or when an object falls and strikes a worker.
Well, but there's plenty of, since Runner, there are plenty of exceptions to what you just said, but you can continue as far as I'm concerned. Sorry, Jenny.
Well, there was there was testimony that there was a boom, the sound, a boom.
Yes, so there is, but
is it fair to say that that would that happened from the sound of the pipe striking the ground?
Yes, so the pipe struck the ground, but at the point.
And so would the pipe have struck the ground? Wouldn't have been on the ground then? It would have had to have come from some different height to.
Yes, at this point, it's unclear what might have caused it, but given the lack of discovery.
Do we need to know precisely what caused it when the whole point was to get it onto this flatbed and it was on the ground and we heard it boom? So whether it fell off of the fork or it rolled off of the truck or whatever, it fell from a height, and that's what caused it to start rolling. I mean, it's fair to say something like that doesn't go boom if it's.
So yes, so by the time.
So let's go from that point.
Yes. So assuming that the pipe hit the floor and started rolling, at that time, the worker, the appellant, was still a safe distance, 15 feet away. So instead of staying a safe distance away, he chose to encounter the pipe. And I know the appellant cited the Lopez case. The Lopez case is a little different because in that situation, his coworkers were clearly endangered at that point. So it's foreseeable for someone seeing that his coworkers were in imminent danger to jump and grab the bolt. But in this case, everything in the records doesn't show if there's anyone in the way of the pipe. In fact, the pipe was rolling towards parked cars. And based on the only.
So there's property. It's not people, but it's property. So it's another weighing factor for somebody who is in the position of supervision or something. I think he's got some greater role than the person who's just the average worker. Is it
I guess still pointing to the
Fair to
difference
say
with
that
the
it was
case.
could one say that it was a reasonable response and that it was comparative negligence as opposed to sole proximate cause or something like that?
Yes, so given his experience as a foreman, and given that Mr. Sal Leopoldo had talked about the company's policy and how it was against policy, and his experience, he should have known that the plank that he grabbed would not have stopped the pipe. And instead of just staying in a safe position where the company placed him in, he was a safe
Well,
distance
no, it's
away.
the opposite argument. The argument is that he's the foreman. He is responsible for what's going on. So therefore, would it not be foreseeable that the individual who is the foreman, who is responsible for the site, would not try to prevent, in this case, property damage from occurring by this pipe rolling on to these parked cars? And I know that you said there was nothing in the record concerning individuals, but we're talking about property damage. I don't know if there's anyone in the parked cars, but again, would that not, that not be foreseeable?
I do not think so. That'd be foreseeable for a person to encounter an 18,000-pound pike that's going towards property and putting their own life at risk to save someone else's property. And from the photos, the only photo we have of the accident, there is no one. It looks like nobody's occupying the carts at the moment.
But we were talking about Lopez where there were individuals. So in this instance, we're not talking about damage to individuals or injuries to individuals. We're talking about property damage, which is, akin to it, right? Because you're still talking about damage which occurred as a result of which incurred as a result of what occurred on the site, the job site.
I'm sorry. Can you?
So Lopez talked about injury to individuals. Is that correct?
Yes, that's
Here
correct.
we're talking about property damage to property. Isn't that kind of akin in terms of the analysis in Lopez?
I do not think so, especially as a foreman. The foreman, I think you guys discuss how they have the responsibility to have higher responsibility than normal workers, and saving coworkers, I think, is a greater responsibility. And even at this point,
Well, it's a greater responsibility, but the point is, isn't it also something that someone who has greater supervision would be taken into consideration to limit any fallout from such a thing, limit any damage, and therefore try to stop it, whether it's property damage or damage to someone?
yes, Your Honor.
Injury to someone. But anyway.
Mr. Leopoldo, in his affidavit, said that it's against company policy for them to.
Excuse
I
me,
understand.
counsel, do we have a copy of the policy?
We do not have the copy of
In
the
the
policy.
record?
Nothing in the record yet, but there's no really discovery that's been conducted in this case yet.
Thank you.
Yep.
Your Honors, unless there's any questions, I'll cede the rest of my time.
Thank you.
Thank you very
Thank you
much.
both. People versus Sam Valentin.
Good afternoon, Your Honors. May it please the court. My name is Mark Lee. I'm pro bono counsel for defendant appellant Sam Valentin. This is Mr. Valentin's first and only felony offense after an unusual, abusive, and dysfunctional childhood. We're here today seeking a reduction in his post-release supervision sentence from 10 years to the statutory minimum of 5 years because Mr. Valentin's current PRS sentence will subject him to unnecessary monitoring that will make it more difficult for him to integrate into society.
So, counsel, if I may, I'm over here in the screen. It's okay. Given the fact that the less is more act is in effect, and it shaves off 30 days from the PRS term for every 30 days of good behavior, doesn't the defendant automatically benefit so long as he does everything that he's supposed to do? Do we really have to intervene here?
Under less is more does not divest this court of their powers to reduce his sentence in the interest of justice. I think recently in People v. Briggs, this court reduced the sentence, even after less is more. Less is more acknowledged that there are detrimental effects of post-release supervision. There's tripwires. While they removed some of them, not all of them were removed. There's nothing in the less is more statute that requires a floor. So if we reduce his PRS to 5 years, there's nothing in the less is more statute that it cannot go below 5 years. This court still has the power and can exercise that power in the interest of justice. PRS is supposed to assist in the rehabilitation and reintegration into society while also allowing for monitoring of Mr. Valentin. Mr. Valentin will be monitored until 2041 under the requirements of SORA. He was found to be a level 1 sex offender under SORA, which is the lowest level, which means that he's the least likely to reoffend and he's the lowest risk to society. So we're asking to reduce his PRS because he's going to be under this dual layer of monitoring for well beyond the time that the PRS is going to help him rehabilitate himself.
Oh, I didn't see that in your brief. So your argument is that because he's a level 1 and he's going to be under supervision for that, then therefore he should not have post-release supervision as well? He should have a lesser term of post-release supervision?
Yes, I believe that was in the brief.
Oh, I missed that. The other thing I did notice was that he had already violated probation, right? He has a prior violation of probation, which was a supervisory sentence, yes?
Yes, yes. But he has this is his first felony offense, and so
Right, because he only has the 6 prior misdemeanor offenses, I think. My point was that he doesn't seem to, he seems to be the perfect candidate, perhaps, for supervision, given the fact that he already violated the probation.
So he is under supervision now. We're not asking him to not be under supervision. If we reduce the sentence today, he'll still be under, even under less is more, he'll still be under supervision until 2024. And so,
which is kind of like only a year.
Right, and he's currently dealing with programs with that PRS mandated programs, and he's participating in them. He will be ready to be released.
How did you get that he would only be under supervision until 2024? I thought you wanted he was sentenced to 10 years post-release supervision. You want 5 years post-release supervision.
That's correct. I'm saying even under less is more to address right, so.
I still don't see how you got 2024.
July 2021 and 2.5 years.
2021 is when he was released in 2021?
Yeah, July 2021.
Oh, so that's interesting. So again, he's finished his incarceratory sentence?
That's right.
And so you're asking us now to reduce it to 5 years post-release supervision, so he would only have technically another year of supervision?
No, so he had 10 originally.
Right.
We're asking for 5. The question was, what happens under less is more? If he continues to participate under less is more, then it would be 2.5. Our argument is that he will be under supervision under SORA until 2041, right? So that he will already be monitored. The question is, will this additional 2.5 years under PRS assist in his rehabilitation or hinder it? We submit that it will hinder it, and that the safety of the community is not harmed by reducing it because he will already be under a different monitoring system as well. So what we submit to you today is that these extra years are not necessary. They're going to be unduly burdensome, and we ask that you reduce the sentence.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Juliana Susu for the people. As an initial matter,
Do you agree with what I think your adversary was saying, that being under SORA's reporting requirements is equivalent to being on post-release supervision?
It's not, Your Honor. The requirements as a level 1 sex offender under SORA merely requires that annually defendant provide information, including his name, zip code, photo, offense, and that goes to vulnerable populations. That's for the safety
And
of
his residence.
And his residence, yes, Your Honor.
Residence is the most important thing.
Yes. While the PRS, that's meant to help the defendant, and it's meant to help him rehabilitate and reintegrate into the community by providing structure and support through counseling programs, management, and so forth.
And the SORA reporting for the level 1, you said, is once a year?
It's once a year, annually, yes.
As opposed to the PRS, which is monthly or whatever is arranged?
Whatever is arranged. I don't know the specifics on his PRS. The combination of these two would not adversely affect the defendant from rehabilitating. As well, Your Honor, the defendant's sentence should not be reduced on appeal because he received an appropriate sentence as part of a fairly negotiated plea in light of the serious and violent attempt to rape the victim while in the same room as the victim's young children, the fact that defendant was on probation at the time he committed the crime, his refusal to express any remorse or responsibility for his conduct even after pleading guilty, and defendant's threats and hostility towards the victim both before and after the crime had occurred. Additionally, Your Honor, part of the reason defendant received a lenient sentence, which was the statutory minimum prison term and a PRS directly in the middle of the 5 to 15-year range, was because the lower court was aware of and fully took into consideration defendant's childhood circumstances. Under those factors, we ask that you affirm. Thank you.
Thank you. You're here pro bono, and the firm is? Thank you, and thank the firm for your service. Thank you. Thank you both. HOV Services versus ASG Technologies.
Good afternoon, Your Honors, and may it please the Court. Shannon Jost for Appellant and Cross-Respondent, ASG Technologies. The software licenses at issue in this case are term licenses. They state on their face the express dates of the software licenses granted therein. If you look at Exhibit D, Exhibit D at R169, the license term is from 2015 through September 29th, 2018. The 2005 SLA, which must be read together with each of the software licenses that are expressed in the exhibits, states at R148, it's Section 9 of the 2005 SLA, that on termination or expiration, HOV was obligated to stop using the software, to remove it from its systems, and return it to ASG. So HOV knew when it signed Exhibit D back in 2015.
So Exhibit D is you just said it's a 2005 software license agreement, right?
No, Exhibit D is the term license agreement that ran from September 2015 through September 2018, correct.
Right, and then Exhibit E extended it from September 8, 2018 through September 2023.
That's correct.
Okay, and so your argument is what?
Our argument is that HOV knew when it signed Exhibit D in 2015 that as of September 29th, 2018, the date that those term licenses expired, HOV would have no further right to use the ASG software. It would have to remove it from its systems and stop using it. unless it signed a new
So
software agreement.
that argument is that it should come to no surprise to them that it was going to end. So their claims against you, that you stopped it abruptly or whatever, that should not inure to their benefit.
Yes, Your Honor, that's exactly right.
So you had no duty to extend or to renew it, and that you were within your rights to allow it to expire under Exhibit D.
That's exactly right, Your Honor. And that's the crux of, for example, the economic duress claim, which the lower court denied on both our motion to dismiss and our motion for summary judgment, despite the fact that HOV relies only on ASG's, and I'll use the word threat because it's HOV's word, but ASG's exercise of its legitimate contractual rights under Exhibit D to prevent HOV from continuing to use the software.
But that was the point, because their argument is, so one of their arguments is that they did engage in, or attempt to engage in negotiations with you in order to renew or to extend.
No, Your Honor, it's actually the flip of that. ASG is the licensor. ASG began communications with HOV as early as March of 2018.
And there was no response at first.
Right.
There was no response, exactly.
And there were letters warning them that there would be an expiration at some point in time, right?
Yes, Your
September
Honor.
29th?
Yes, Your Honor. And the reason that HOV wasn't responding is because, unbeknownst to ASG, HOV was in the process of trying to migrate off of the ASG software. It wasn't until September that HOV finally agreed to engage with ASG, and then it simply didn't like the terms on which ASG was willing to grant a license. But there's
Also, the premature expiration due to the I guess coding glitch. How does that factor into this?
It doesn't factor at all into the economic duress.
It happened to have happened on the last day of the license.
It did. That's exactly right. And Exhibit D, again, allowed HOV to continue using its software through the end of the day on September 29th, 2018. When the key expired prematurely at midnight, ASG promptly remedied it, and HOV had installed that key and was back in gear using the ASG software through the end of the Exhibit D license term, at least 12 hours before it ultimately signed Exhibit E. So that's the economic duress claim. The implied covenant really is part of the same cloth. There's no extra contractual right that HOV can create through reliance on the implied covenant. And it certainly can't imply a right, such as a continued right to use the software without a license, that's inconsistent with the express license terms.
One quick question, counsel, as to the amount of a new extension, right, past the September 29th, 2023. Am I right? 2023 date? Am I wrong?
What HOV wanted was a short, cheap license extension. It didn't want to pay for the Exhibit E terms that ASG was willing to offer. So you're right, HOV claims that what it wanted was a 5-month or a year extension. But ASG was under no obligation to grant that at all. The license is...
I'm sorry, was there any requirement that you increase the amount by increase the amount according to any formula, for example?
No, Your Honor. There was nothing about that in Exhibit D, nor was there anything about that in the 2005 SLA.
Was there any reliance on past practices or any course of dealing that would have justified, in your eyes, or in their eyes rather, a price increase of the magnitude that your client wanted?
Well, I'm sure HOV's counsel will tell you that yes, there was, but the truth is that there's no legal obligation for ASG to grant a renewal license at all, nor on any specific terms. And in the negotiation, the parties ultimately signed a deal in Exhibit E that accepted the price that HOV said it was willing to pay, namely $500,000 a year.
Thank you.
Richard Schoenstein for respondent. May it please the court. Let me start right where you left off, Justice Gonzalez, at course of dealing. This wasn't just one contract. This was a series of license agreements and amendments over 16 years. The price was $170,000 a year to lease this software. And 5 days before expiration, ASG said, now we want 5.9 million, not 170,000 a year, 5.9 million, and it has to be paid all up in front in the next 30 days. This was a complete shock to HOV. It was a total departure from the course of dealing between the parties. There was no justification. We took extensive discovery. There was no increase in cost for ASG. There was no economic justification for their demand other than they thought they could get HOV to agree to it. And it
So
was
here's a follow-up question to what I had asked your adversary. There was correspondence stating that the expiration date was coming nigh, right? But supposedly your client did nothing to move the needle as far as obtaining a new extension. What do you have to say about that?
Well, the record contradicts that. Our client responded in May of 2018 and tried to get negotiations going. The two parties were just on a different page.
So it's not accurate. I think the record indicates it started with ASG reaching out in March of 2018?
Correct. And there was a response from HOV by May.
In May. That's 2 months?
That is 2 months. And by the way,
Then in June, I think ASG reaches out again?
And there was more response. I mean, these are issues.
No, but that's not last minute. You say 5 days before. You know, they clearly, they were trying to get some movement with regard to.
But the price was announced 5 days before. The fact that they wanted $6 million instead of $170,000, that wasn't announced until 5 days before. And one of the letters Your Honor referred to, what they call in the record a judo letter. We never did find out what judo stands for. That was sent on September 28th. And that letter not only said you can't use the software, but you cannot get your data back. And that is the key to the duress. They weren't just going to cut off the software. HOV would never have been able to access the data that its clients, insurance companies, doctors.
Okay, but counsel, so as to that part of your argument, where I'm going to use the word blame, and I use it without judgment, okay? But where does the blame or the responsibility lie if things weren't working out for so many months before the deadline date? Your client surely had the opportunity to have a backup plan to transfer data someplace else, right?
Well, I mean, I guess that's possible, but that is an issue of fact as to what parties, and we have sharp disagreements about that, about when the negotiations started. ASG's own witnesses said they usually start negotiations a year in advance, and they didn't reach out until 6 months in advance. We say we did respond. We say we did try to engage, and HOV says it was totally stunned and surprised by this dramatic price increase at the last minute.
And your client made a hard offer or a counter offer to whatever was said?
We did, yes. They negotiated the ransom, but it was still ransom. They negotiated it down from $5.9 million to $2.5 million, but only in an effort to keep the system on so these underlying customers, these doctors and patients and insurance companies, could still get their data. And then immediately after that negotiation stopped, HOV went to court and started an action to try to sort this all out. It didn't need a 5-year license. It didn't need all the servers ASG was trying to sell it. It didn't want any of that, but it had to keep the system on. And whether it was right or wrong in doing that is an issue of fact for the jury. It's not an issue of law. They have some good arguments about whether or not HOV was responsive enough. They have some good arguments about what the parties thought, but they're arguments that need to be determined by a jury. This case is going to trial no matter what you do with these motions because there are claims and issues that weren't decided on summary judgment. So we're going to a jury trial. I think it's currently scheduled for February 2024. All of these other issues, duress, waiver, estoppel, they hinge on those fact issues. They hinge on witness credibility. We have a right to try those issues to the jury and let them decide. And Justice Borak, who has done a great job with this case, and I love Justice Borak, but he decided too many fact issues in granting summary, in part of his summary judgment determinations here. That's why the duress claim, by the way, he did not strike the duress claim. He left that in. That is what ASG is appealing. He did strike portions of the waiver and estoppel defenses. We think those should come back in because those two are fact issues. I thank you all for your time. It's good to see you in person.
Thank you.
Your Honors, I'll be brief. The undisputed facts are that when Exhibit D expired on September 29th, 2018, there was no right for ASG to continue using the software. HOV's executives testified in deposition that the reason they signed Exhibit E, which was negotiated by HOV's executives and in which both parties compromised, the reason they signed it was because they needed continued licenses to use the software. We hear from their CFO at R 2694-95 and their COO at 2676-77, both saying they understood that the Exhibit D licenses ended and that HOV needed a license to continue. There is no right in a software license to renewal on any specific terms. And when HOV said in May of 2018 that what it wanted was a short-term license, ASG responded and said, we don't grant short-term license. You'll need to participate in a health check. You'll need to give us information about your deployments in order to get a right-sized software license. HOV said at the beginning that it would do that, and then it refused. That's where the $5.9 million license came from that ASG first provided, because ASG didn't know the scope of HOV's deployment, and HOV provided false information during negotiations. Ultimately, the parties signed the agreement, and on the basis of HOV's execution of Exhibit E, ASG was induced to provide license keys that allowed HOV to use the software during the term of Exhibit E. Not for a day or two, but for at least 5 months, and HOV's executives testified that they kept the software on their servers for a year. So we are looking at a significant period of time during which HOV doesn't want to pay for the software licenses at issue. I wanted to talk very briefly about the fraudulent inducement claim.
I'll give you a little bit of time to do that.
Thank you.
I was going to give you a little bit of time to talk about that, but
Oh, thank you. I'm sorry, I misheard. On the fraudulent inducement claim, HOV has admitted that there's no fiduciary relationship between the parties, and absent a fiduciary relationship, a duty to disclose facts here, the possibility of HOV's breach of the overlapping customer provision, the duty doesn't arise unless there are special facts, but those special facts have to be peculiarly within one party's knowledge, and there's a duty to inquire. HOV concedes that it did nothing during the entire course of Exhibit D or Exhibit E to investigate whether it was in compliance with the overlapping customers restriction. It didn't ask its own customers, it didn't ask ASG, and on those facts, HOV simply cannot maintain that claim. Thank you, Your Honors.
thank you. Thank you both. City of New York versus Philadelphia indemnity.
Good afternoon, Your Honors. May it please the Court. Anthony DiStefano for Defendants Appellant, Philadelphia Indemnity Insurance Company. The plain language of paragraph 2 of the abuse or molestation endorsement in Philadelphia's policy bars coverage for the underlying claims of negligent investigation and supervision that were levied against the city by the infant plaintiff and her mother regarding abuse that allegedly occurred while the infant was in the Storefront Academy of Harlem Charter School. The abuser was Mr. Johnson. Mr. Johnson was placed in the academy by Bronxworks. Bronxworks is Philadelphia's named insured. The allegation is that Mr. Johnson abused the plaintiff while
Counsel, just to interrupt you, it's your burden to prove the exclusion applies, correct?
Correct.
And also, you have to show that it's wholly within the exclusion. And so here we have facts which may indicate that the child, ZH, was at Storefront, and Storefront is not an insured, and therefore the exclusion does not apply.
Sure, Your Honor. So within paragraph 1, that involved the care, custody, and control, and that was the location of the infant at the time the abuse occurred. What we're arguing is that irrespective of paragraph 1, paragraph 2 bars the claims of negligent investigation of Mr. Johnson and supervision of Mr. Johnson. And it's that one that the motion court found did not apply because the paragraph 1 exclusion regarding care, custody, and control did not apply. In other words, the motion court is saying—
Counsel, there's an or between paragraph 1 and paragraph 2. So how do you get around that? The child was not in the custody, care, control of the insured. Isn't that a check and we're done?
Check with regard to only to the care, custody, and control allegation, not the negligent investigation allegation. That's what we're saying. What the court here found was that we must defend and provide coverage for the negligent investigation allegation, and we're saying that that can't be because the plain language of paragraph 2 bars coverage for that claim. Irrespective of paragraph 1, we're not here arguing care, custody, and control. We've made that clear in our brief. That's not an issue that we're saying. What we're saying is that paragraph 2's negligent investigation claims for negligent investigation are barred by the plain language of the exclusion. And the court found that it did not because paragraph 1 did not apply. In other words, the court basically deleted paragraph 1. But what paragraph 2 says—
But if we say that the court wasn't correct about eliminating paragraph 1, and paragraph 1 applies,
the conduct in paragraph 1 applies. So paragraph 2 says that it's any conduct defined in paragraph 1, which is threatened, actual or threatened abuse or molestation. That's what we're saying is barred by paragraph 2, not the care, custody, and control. The argument about whether or not there's a duty to defend, what we're saying is that the motion court found that there was no basis on which the city could be held liable for care, custody, and control. There was really no allegation of that. So the motion court is saying that really paragraph 1 doesn't come into play because there is no liability there. So what we're saying on the duty to defend is that if there can be no liability against the city, there can be no obligation to indemnify for care, custody, and control, and therefore no obligation to defend. That's a different argument than the one that I started this argument with, which is that any allegation of negligent investigation or supervision for purposes of indemnity, that has to be excluded. We cannot be obligated to provide coverage for negligent investigation and supervision. That is plainly excluded by this policy. So that much of the order needs to be reversed. It needs to be modified, and that's stricken from the order. Whether or not this court ultimately finds that there's a duty to defend—
You're talking about the duty to indemnify, I see. I didn't see that there was actually a finding by the court that there was a duty to indemnify. I thought it was just a duty to defend, but okay.
Right, the court said defend and provide coverage for. The and provide coverage for is indemnity. And we cannot—
you would agree, counsel, you would agree that there is a duty to defend because paragraph 1 of the exclusion is met?
Right. What I'm saying is that I would argue that paragraph 1, when we're looking at that language, either there is no care, custody, and control, and therefore the city cannot be liable, and therefore Philadelphia can never indemnify.
I'm talking about the duty to defend,
Right,
not the duty to indemnify.
Sure,
Okay.
but if there is no duty to indemnify, then there is no duty to defend. That's what the courts have held. So that's where I was going with the duty to defend argument. If we can never be obligated to indemnify, then we're not obligated to defend. But I realize that courts have held otherwise, that where there's at least an allegation of that,
Right.
that there still is a duty to defend. So ultimately, this court may still hold Philadelphia responsible. I would wish that you don't, but ultimately, I understand that the court may do that. But however, with respect to the duty to indemnify and the negligent investigation, that has to be taken out.
Thank you.
Thank you.
May it please the court, Kate Fletcher for respondents. The city is not arguing that at this particular juncture, Philadelphia has an obligation to indemnify. We are, however, arguing that it does have an obligation to defend. And the reason is because as Philadelphia concedes, paragraph 1 does not bar coverage. And as well, paragraph 2 also does not bar coverage. And that is because in order for paragraph 2 to bar coverage, it must be found that the injury arose from negligent employment or supervision or investigation of a person for whom the insured was legally responsible and whose conduct would be excluded by paragraph 1. Neither of those conditions is met in this case because paragraph 1 excludes conduct that occurs in the care, custody, and control of an insured, which there is no dispute is not alleged here. So therefore, paragraph 2 does not bar coverage. In addition, it doesn't bar coverage because neither the city nor the Department of Education was legally responsible for Johnson at this time, and because the allegations in the complaint fall outside the narrow confines of this exclusion, the Philadelphia has a duty to defend. They have an obligation to show that there is only one reasonable interpretation of the exclusion and that all of the allegations in both of the complaints fall entirely within that, and they did not meet that obligation. They did not meet that burden.
Thank you.
Thank you.
The language of paragraph 2 is that it's a person for whom any insured. It does not have to be the city. It could also be Bronx Works. Bronx Works at some point in time was legally responsible, at the very least, if not continuing, while Mr. Johnson was at Storefront Academy. Specifically, they either hired or placed Mr. Johnson at the academy. That is the level of legal responsibility that is enough to meet paragraph 2's exclusion, which is any insured is or was legally responsible for the abuser. Here,
Counsel, could you just parse what you're saying? Are you referring the duty to defend or the duty to indemnify or both?
this is for purposes of indemnity.
Thank you.
Okay? So the second part of it is, so once we've established that Mr. Johnson, at some point, Bronx Works was legally responsible for him, if not even continuing, because they did have a continuing obligation to monitor Mr. Johnson while he was at Storefront Academy, is what was the conduct? And what the city is arguing is that conduct includes both actual or threatened abuse or molestation and care, custody, and control. But care, custody, and control is not conduct. The plain meaning of the word conduct is something that, an actor does, and here that's actual or threatened abuse or molestation. So here, again, we have a person for whom Bronx Works was or was legally responsible, who engaged in conduct, the actual or threatened abuse or molestation of the infant plaintiff, and for that reason, there can never be an obligation on the part of Philadelphia to indemnify for those claims. And I also urge this court to look at its decision in Madison Square Boys and Girls Club for that point as well.
Thank you. Thank you both. People versus John Nocia.
Good afternoon. Margaret Knight from the Office of the Appellate Defender on behalf of John Nozea. Where there was weak evidence of the cause of the complainant's injury, a critical element necessary to sustain the second-degree assault conviction, it was error for the trial court to allow an impermissible hearsay to fill in a gap in the prosecution's case, specifically the purported excited utterance of Ms. Gao, the complainant's husband, that the umbrella was the cause of the injury. While the prosecution failed to establish an exact timeline for the supposed excited utterance, what is clear is that it was after Ms. Gao had already spoken with one police officer for approximately 10 minutes. When she spoke with the next police officer, he described her demeanor as scared and nervous.
Counsel, didn't Mr. Ding testify directly that he was hit by the umbrella on the head?
He did testify, but he also testified that he was hit by the umbrella after he had fallen to the ground and that the injury to his head preceded the fall to the ground. Mr. Ding's testimony was inconsistent on this regard. He definitely testified that the umbrella had caused the injury, but he testified as well that he had injured his head before he fell to the ground, and then he testified unequivocally, that's when he started using the umbrella, when you were already down, yes. Ms. Gao could not testify as to where her husband was hit with the umbrella. Wei Ding admitted that although he had assumed that the injury was caused by the umbrella, that that was only because that is where he saw the injury was. There was no medical testimony that this injury was consistent with an umbrella as opposed to other objects. In fact, there were at least 2 other causes of the injury that would very obvious. One is that the complainant testified that he was being struck by fist to his head exactly where the injury was. He also said that he fell down to the ground and that he didn't really recall. He was understandably, we're not minimizing the injury, that he was dizzy, disoriented at that point, and that he really didn't recall very well what happened. So Ms. Gao's testimony was critical in filling in that gap in the proof. It's the only very straightforward evidence that the umbrella was a cause of the injury to her husband's head. And Detective Wrong did not testify that she was panicked. He did not say that she was shaking. He did not say that she was crying. He had a hard time even recalling, exactly what her demeanor was. So for all of those reasons, the foundation for an excited utterance was not established. This was very important evidence, and the conviction should be reversed on those grounds. I would like to touch on one other error that happened during the trial, where the court took the unprecedented step of interrupting the prosecution's lead detective's testimony.
I agree that it was unprecedented. Was it preserved? Was there any objection at any point to that?
No, there was not, but we are asking Your Honors to review this in the interest of justice, both because it was such an egregious deviation from the court's role as a neutral arbiter into the shoes of an advocate, and also because this is a hard thing for an attorney to object to. The court had upbraided the witness, called him a disgrace. When the prosecutor tried to defend the witness, said, "I lay this at your hands." Certainly counsel should have objected, but part of counsel's argument was that there was a poor police investigation. Detective Wrong is the witness who testified to this excited utterance that I was discussing earlier. So if the prosecution had not been allowed to meet with his witness, fix his testimony, the jurors might have further reason to doubt the accuracy and credibility.
Counsel, why was it hard to object? I missed that part. It seems like that's all of us, or I don't want to speak for everyone, I read this transcript and just was very surprised. And so why not just say, Judge, I object, let's continue with the testimony.
I absolutely agree that the attorney should, but when a judge is that frustrated and is calling out both the witness and the prosecution as being disgraceful, the attorney may have been nervous or reluctant to incur further ire. I don't know. I agree, Your Honor. He should have objected, and it's unpreserved, but we do ask Your Honors to review it in the interest of justice.
afternoon, and may it please the court, Jennifer Westfall for the people. I'd like.
Also, describing her as scared and nervous, is that enough of a foundation for an excited utterance?
I think given the entire context of the situation, I think there was more than enough here to show that Mrs. Gao was in shock and stress from the brutal assault on her husband. To begin, her husband remained in poor shape. He had bled through entirely a white rag that she was trying to hold to his head. She didn't leave his side. She was saying, "My husband, my husband." She was very visibly distressed over his health condition. And Rong said that she was scared, afraid, and nervous. She was so nervous that she spoke in her native tongue. Her tone of voice indicated fear. I think that there's no requirement that she cried. There's no requirement that she be shaken. But her husband was beaten over the head and was still bleeding and was dazed and unable to answer questions in the immediate aftermath.
With regard to beaten over the head, is there any other clear testimony that he was hit with the umbrella before he landed on the ground, where he was further beaten with the umbrella?
I think the thrust of counsel's argument mischaracterizes Ding's testimony. Ding's testimony is the best evidence for the order of the attack and what exactly caused his head injury. To begin, it's important to remember that there was actually a language barrier. Ding testified that he had very, very limited English, and there were clear instances throughout his testimony where he appeared confused and often asked clarifying questions. What was clear throughout his testimony, however, was his consistency in describing the assault, and particularly with respect to the progression and escalation of the defendant's attack. He testified on multiple occasions, including just sentences before the single instance that counsel highlights, that defendant first hit him with his fists, but that notwithstanding those blows that left him dizzy and in pain, he remained standing. Ding repeatedly added after that, again, including during cross-examination, that it was only after defendant's first hit with the umbrella that Ding felt his head crack, and then he fell to the ground, where defendant continued to beat him continuously with the umbrella. Ding never said that he hit his head on the ground. He said he did not remember. But the location of the injury itself, at the very top of his head, suggests that it would be quite difficult for him to hit his head on the ground and incur that
Counsel,
injury.
there's no testimony that that the complainant, Mr. Ding, was pushed to the ground, fell to the ground, slipped on the ground, is there?
No, there isn't, Your Honor. It was the umbrella strike, and then he fell. In claiming that this particular response, the single incident where Ding suggested that, or answered that that's when he started using the umbrella, when you were already down, you have to overlook Ding's earlier repeated testimony about the direct cause of his head injury, including just sentences before this response, and also you have to look at the context of that statement. In fact, the context of the surrounding questions by defense counsel and Ding's corresponding responses revealed, beyond perhaps some confusion on Ding's part as to the line of questioning, that he was intent on conveying that defendant had not ceased to hit him with the umbrella once he was down. Significantly, too, Ding simply never testified that he hit his head on the ground or that he had felt his head crack while defendant was hitting him with his fists. He specifically highlighted the umbrella strike for that crack. Therefore, Ding's testimony is the best evidence of that cause of injury and is supported and corroborated by the people's remaining evidence.
I'd like you to turn your attention to the judge's interaction in this trial. How should we address that?
I would like just to bring to your attention again that this is entirely unpreserved. Counsel should have made the objection, and certainly the people were going...
In the interest of justice.
Yes. I would say that there was no harm whatsoever, as evidenced by the lack of objection. Also, this was outside of the presence of the jury. The judge only told the jury that they would continue Wrong's testimony the next day. There was no representation of bias. The judge was even-handed when he spoke in front of the jury, and he did not say anything in favor of either party in front of the jury. He didn't provide the people with an opportunity to correct or clean up damaging testimony. Wrong was testifying about merely collateral matters and was simply repeatedly asking to refer to his memo book and to refresh his memory. And the judge lost patience. Simply put, the record shows that the court's imposition of a break in Wrong's testimony had no deleterious effect on the trial and served only to clarify the minutiae of collateral matters in his testimony. To clarify and secure more professional testimony in the judge's opinion, the court essentially granted Wrong a break to gather up his thoughts, review his notes, and come back better prepared to deliver factual testimony.
That break was not sought after, right? The prosecution didn't ask for a break.
No.
It's the court on its own decided that this witness seems unprepared, therefore you should go and prepare your witness. Is that fair?
There is no evidence in the record whatsoever that the people actually met with Wrong. There was no change to his testimony.
Well, whether that happened or not, just the fact that the court gave the prosecution that opportunity, isn't that beyond the scope of what the court is supposed to do?
The court has the power to ensure that the trial proceeds in an appropriate manner and that the jury is delivered factual information
Yeah, but if the prosecution decides to bring an unprepared witness, isn't that the prosecution's problem?
I would suggest that the witness was not unprepared. He had problems remembering specific building numbers for where he got the video, which, okay. He also was starting to stutter over where and when he pulled the book.
Counsel, if a defendant was stuttering on the stand and couldn't remember the testimony that he wanted to give, would it be appropriate if the judge said, counsel, you know what, you need to talk to your client so that he can give a smoother delivery to the jury? Why don't you, we'll break, put on a different witness, he can come back tomorrow. We'll pick up from there. Would you not say that it was outrageous?
I think that this is more comparable to a break at the end of the day in between testimony.
But there was no break at the end of the day. This was in the middle of the day, wasn't it?
No, it was in the middle of the afternoon towards the end of the day.
Right, middle of the end, and then somebody else was put on the stand.
Right, you took someone out of order.
Because the Mandarin interpreter was there, yes, and it was a civilian witness. I honestly think there was no harm to this. Wrong's testimony did not change. We did not clean up his damaging testimony. And defense counsel had multiple opportunities to refer to the perceived inadequacy of his investigation. He launched on multiple lines of condemning the investigation. There was no harm and there was no impact in that line of argument.
Thank you.
Thank you.
Counsel, when the questioning resumed on the following day, did the defense counsel question the witness as to what conversations the witness had or didn't have with the prosecution? So one would think that's one of the first questions you would ask.
Defense counsel did not, of course, the jurors were not, as respondent notes, the jurors were not aware of this. Defense counsel did not ask us that question, but building on Judge Renwick's questions, if an advocate asked to take a break in the day just because they had not adequately prepared their witness, it would be outrageous and likely reversible error, and it's even worse for the judge to do the same. It's absolutely respondent's argument that we don't even know that the prosecutor met with the witness is not only speculative, but very likely inconsistent with the court's order on 112. Well, listen, I'm listening to this testimony and it's not clear, so work on it. I'm giving you overnight to get coherent testimony in front of the jury. It's your case, so I say it's contrary to common sense that any attorney wouldn't at that point meet.
Well, is it, counsel? Because I think that the prosecution kind of fought back on that, right? They didn't necessarily want the break. And the fact remains that defense counsel could have and probably should have inquired as to what conversations were had, but didn't.
The prosecution defended Detective Wrong's performance and defended his own preparation. He certainly didn't object that it's harmful to me to have a break in the testimony to further prepare my witness who is struggling, who's referring to notes, who has a poor recollection of some of the events. And defense counsel's argument, summation, I do wish he had asked more about it, but part of his summation was based on this fairly poor police investigation. It was obviously successful to some point because the jurors did acquit of most of the charges, but here we have this remaining assault conviction, and going back to the excited utterance, Detective Wrong is the one who testified that. If I may make one quick point to respondent says that Ms. Gao was in shock. Detective Wrong was fully capable of testifying when someone was in shock. He said that her husband was in shock. He did not say that she was in shock. And the statements, my husband, were made to Officer Randy Chan, which was the interview that preceded the questioning by Detective Wrong. Thank you, Your Honors.
Thank you both. Elite Wine versus Michelangelo Preservation.
May I film?
Sure.
Thank you. Good afternoon, Your Honors. May it please the Court, Joseph Servini, representing Appellant Michelangelo Preservation. The issue on this appeal is whether the lower court improperly granted an untimely Yellowstone injunction. The law on this issue is very clear in New York. A Yellowstone injunction needs to be filed prior to the expiration of a cure period. One thing to note is the lower court, in its decision, incorrectly cited the law and stated that it can be filed up until the time of the lease is terminated. That is incorrect. There is also a limited exception to that rule, which states that in the event a lease includes a specific provision extending that time if a cure can't be cured during the cure period and there's good faith efforts to cure, it can be extended. That didn't happen here.
Counsel, there was a non-payment stipulation here. Did that stipulation have any effect on this action?
No, Your Honor. That was...
It had language in it that said that the stipulation was, I'm sorry, I'll read from it. The agreement settles all claims between the parties hereunder except it's set forth herein.
Hereunder is the important word there, Your Honor. I mean, that was a non-payment proceeding. There's a few facts about this stipulation.
Well,
First,
counsel, stop 1 second. Aren't these the same parties?
Yes, Your Honor, but if you look, only counsel signed this. There were no parties signing this. So the concept that an intentional release of all claims could happen in a non-payment proceeding.
I don't understand, counsel. This is a stipulation of settlement that was filed in court, and it's a two-attorney stipulation. So what are you saying? I see two signatures here. I see the signature of the firm Gutman and Mintz, and I see the signature of the firm Doyle and Brumond. So why are you saying only one side signed this?
Well, no, both sides signed it, but no party signed this is what I'm saying, meaning for an intentional...
But these are corporate counsel. Aren't these corporations? Aren't the corporations represented by counsel by definition, by law?
In the non-payment proceeding, Your Honor.
By the way, this was a non-payment proceeding. In the complaint, are there any claims with regard to the other issues of repair or anything else? Anything in that complaint other than the non-payment?
There is nothing in the record, Your Honor, to support anything other than this was a non-payment proceeding, and that is included in the testimony of respondent, which is on 386 to 387 of the record, in which he said this was purely a non-payment proceeding and none of the other defaults were at issue, Your Honor. And I think,
counsel, so having dealt with many of these over many years, as you know, there's no exceptions to the language here as to all claims. There's no exclusion. There's no restriction of rights. There's no indication that this is signed without prejudice to fill in the blanks. I don't understand it. It appears that this is a binding agreement between fully represented parties as to the settlement of all claims, plain language.
except for the word hereunder, Your Honor, and I think that's an important term that needs to be analyzed. Hereunder.
But counsel, the term hereunder qualifies parties. It doesn't qualify claims. It doesn't say all claims hereunder. It says between the parties hereunder, which is a distinction.
Your Honor, I think we're delving into issues of fact that may not have been properly resolved by the lower court. I mean, I understand the court's position, but to suggest that hereunder doesn't refer to the claims in the non-payment proceeding, I'm not sure at this point that the record supports that understanding, Your Honor.
I think what you mean is, it said, right, the non-payment, and it says this agreement settles all claims between the parties hereunder, except as set forth herein. And the
Yes.
herein, I think, goes back to the claims.
Your Honor, the interpretation that I would preserve, Your Honor, is that hereunder relates to in this non-payment proceeding,
So,
Your Honor.
Counselor, you're not in any way suggesting that these attorneys did not represent the parties. You're just stating that the attorneys represented the parties for purposes of the non-payment.
Yes, Your Honor.
Okay.
Yes, Your Honor. And I think there is an interpretation that's being advanced that what hereunder relates to, that may be an issue of fact that needs to be determined by the lower court with additional discovery or further hearing, Your Honor, because what did the parties intend is essentially what we're talking about here with the word hereunder. And on its face, I don't think on this record
In an action that had no other claims, seems like they were only talking about the non-payment action.
Yes, Your Honor, but under this analysis, every claim that could have possibly existed, whether it could be a repair obligation or whether it would be a personal injury claim, would be released. That can't possibly be what is anticipated by a two-attorney.
Exactly.
But also, Your Honor, if I may, from an intent-based standpoint, after the date of this stipulation, it was respondent still believed it had a repair obligation and actually communicated that in writing. So if it believed this case was settled because of the default, meaning that the defaults were also settled, it put in, Your Honor, it sent an email to the respondent sent an email to Mr. LeConte in which he said, I will repair the sidewalk, Your Honor. If he truly believed what was being said, which was that everything was resolved in that settlement, clearly he wouldn't believe he had a repair obligation with respect to that default. That is an inconsistent position, Your Honor.
Thank you. Do you have rebuttal? Yes. You want to finish your sentence?
No, Your Honor, go ahead.
No, I said, do you want to finish your sentence?
Oh, I was just saying, this is, from that perspective, it does come to an intent-based issue, which is first, what does hereunder mean? And second, if in fact respondent was actually communicating with the respondent after the date of this stipulation about those same defaults and acknowledged it had that obligation, clearly he didn't believe that it settled all claims, Your Honor. And I think that's an important fact.
Thank you.
Should I continue?
No, the red light's been on for a while.
Understood, but we focused on the stipulation of settlement, Your Honor.
You can finish up on rebuttal.
Okay.
Time for the next party.
Good afternoon. If you may please the court, my name is Heidi Brumont, and I'm representing the respondent in this action. What counsel failed to mention to the court is that this wasn't just one incident, one time. They started with a notice to cure back in January of 2019. My client owns a liquor store, South Bronx. He responds. They had a laundry list of items that suddenly they decided he was not in compliance with. If you read that first note, you'll see how they truly wanted to get rid of him. It's pretty clear. The items are listed.
Counsel, in the February response to the initial notice of claim, the tenant, your client, seemed to repudiate any obligation under the ADA. So how does that show any intent to cure that alleged default?
My client believed, and if you look at the lease, I believe maybe even correctly at that time, that he wasn't responsible for the ADA because there's no reference at all to the ADA. However, even with that, Judge, he went ahead and he called people he felt he needed to call, he got information from them, and he created a removable ramp with a sign and a buzzer, which is permitted, which is what you do in instances where you can't have a permanent ramp.
Yeah, but within the cure period, Counsel, I'm sorry, I know that all happened, I know.
It was a
Within
second
the
cure period.
Yeah, okay, we'll hear about that in a
It was a
second. But in
second
the
notice
first
to
cure
cure.
period, after the January notice.
After the January
Let me just
notice-
finish the thought. There was a repudiation of any need to do anything about the ADA alleged noncompliance, and therefore isn't he done at that point because he didn't take steps in good faith to cure the default within the cure period of the initial?
I don't believe he is, because in March of 2019, they sent a second cure notice where they identify that he has to now replace the sidewalk, which wasn't in the lease and shouldn't have been required. He had already repaired the sidewalk, and that he had to conform with the ADA and make the premises accessible.
Were you going to say that the second cure notice, or default notice, the one in March, somehow erased the original cure period? Were you going to say that?
Yes, Your Honor.
Okay, please continue. Why is that the case?
Because it's a second notice to cure. Because they identified and realized that they had to give him more time to cure and explain what the cure had to be. And they did that. And he did, in fact, cure. He, during that time, did the removable ramp, the buzzer, and the witness testified at the hearing for the landlord that he believed it wasn't sufficient because he had Googled it and thought it wasn't good enough. And to this day, there's never been a violation for the sidewalk. There never was. Never was a violation for the ADA. No lawsuits were brought. More, it was the landlord trying any way possible.
What's your best case for saying that the second cure default notice erased the first default notice? What's your best case about that?
When you say best case, John, is another cure. The law is clear. You can at least get a Yellowstone during a cure period unless you're not able to cure, and the lease decides that you have more time to cure if you're unable to cure. That was another cure period.
And you show good faith, though, right?
And he showed good faith. He was actually doing it. And then they said he had to replace the sidewalk. So he hires the contractors, gets the permits, and actually replaces the sidewalk. He was trying to do anything he can. He doesn't want to lose his lease.
Counsel, before you run out of time, what's your argument in terms of the stipulation and the hearing, the language in the stipulation?
We believe the stipulation settled everything, and he testified during the hearing as well that he thought there was no longer any problems because they had brought this action and we had settled it. We had settled it, all the claims were settled. They never brought up, but by the way, this is without prejudice to any defaults under the lease. It's without prejudice to any other defaults or any other claims.
But it says settles all claims between the parties hereunder, except as set forth herein.
And nothing else was set forth herein. Nothing else was set forth.
No releases were exchanged, though, were they, at the non-pay?
No, Your Honor, and I've been doing it for, sadly, over 30 years, and I don't think I've ever done a release, although...
Have you done allocutions of clients at settlements of non-pays?
It depends. In Part 52, which is the commercial part, if it's a pro se respondent, we will obviously do an allocution. With corporate respondents, I don't recall, maybe a handful of times, or depending on the judge.
This is a complaint with only non-payment issues in the complaint. There are no issues with regard to anything else here. So when it says herein, it has to be referring to those things in the complaint. If there were other things listed in the complaint, then that might be the case.
We believe that they were seeking a breach of lease. When you bring in the non-payment, you're saying you breached your lease by failing to make payments. And they could have very well brought up any other item where they're claiming the tenant breached the lease, and they didn't.
But see, I understand that that's what you believe, but is that a reasonable belief, and what would be the basis for that belief?
I think it's reasonable. I think it's reasonable to see it that way because they had served the notices to cure, the 2 notices to cure prior. He had responded to them. They then bring a non-payment.
And I'm sorry. Did you finish the question?
Well, they then bring a non-payment. Clearly, they could have brought, at that point in time, they could have brought a notice of termination and terminated his lease, but they didn't. They brought a non-payment. Now, whether it's because they want to get their money first, and the moment they got their money and they were satisfied, they then tried to terminate his lease, probably what they did and why they did it. But I think it's reasonable to presume that if you get 2 notices to cure and you've responded and you're diligently trying to cure, and now you get only a non-payment proceeding.
I just have to ask you one question again. I know it's been asked a couple of times already, but the cure period ended, the first cure period ended, and your client didn't contact them until the last day of the period, having done nothing at that point. So having shown doesn't seem like any good faith at that point. So how does the Yellowstone happen if you have to be within the cure and show good faith and nothing is done at that point?
Your Honor, there were 9 instances they brought up in that first cure. And in that first cure, 7 of them he actually cured and provided the documentation. 2, he had questions and asks for clarity. When they respond the second time with the second notice to cure, giving him more time to cure again, they say, you requested clarity and we are going to clarify for you. So the fact that he waited till the last day, Your Honor, we're talking about a liquor store owner in the South Bronx. We're not talking about someone who's educated to a point where he would know when to respond. The fact that he responds to every single thing that's sent to him, and the fact that he tries, and the response that counsel is saying after the non-payment proceeding was in response to the termination notice. He didn't even understand why he was getting a termination notice. So he says, hey, what did I not do? I'm willing to do anything you want me to do. And he, in fact, did cure.
Thank you.
Thank you, Judge.
A few quick points, Your Honors. First off, I think it's important to note you asked for a specific case with respect to whether it obviates the first period. As a matter of fact, in the first department in Retropolis versus 14th Street Development, this court stated that each period of cure needs to be dealt with independently for Yellowstone injunction relief. There aren't any cases that they've cited in support of that proposition. Second, even if that was true, and it was a second 20-day period, in his April 17, 2019 response with respect to the sidewalk, he now said he wasn't responsible to fix the raised portion. It was Con Ed. So there was a repudiation during the second period. And I think it's important, Your Honors, with respect to the first period, even though it's a demonstration of good faith, he knew what raised and cracked meant. He knew, but when he received it, this is his testimony, he knew that that was the condition of the sidewalk. More importantly, the lease requires him to hire an independent contractor. He also testified that he knew that was his obligation. And last point, Your Honors, in the cases extending in this department, or in New York State, extending the time, there is actual actions being taken, such as getting a contractor and the contractor saying, I can't fix this in 20 days, or hiring an architect. That didn't happen here, Your Honors. Thank you.
Thank you both.
Thank you, Your Honor.
Are we done? I can't see. You do realize I can't see the bench.
We were it.
That's the end?